Good afternoon, everybody. Greetings to those following us here in live and those following us through the virtual medium online. I'm Gabriele Rizzo. I'm the Director of Research at the Swiss Center for Positive Futures at the University of Lausanne. And we have today a stellar lineup to talk about anticipating risks. How can Foresight support data protection? And I am proud to introduce all our speakers just very briefly with their names, and then I will give you just a little bit brief on their backgrounds when I will give them the floor. We have Jekaterina Macuka, David Barnard-Wills, Stephen Almond, Chris Gomez, and William Malcolm. Jekaterina, I'd like to start from you, as you are a qualified lawyer who worked more than 10 years at the Ministry of Justice in Latvia, implementing the EU regulation and strategic reforms to create a modern and effective governmental sector. You have been participating at the EU Council working on GDPR, and you are currently the head of the Data Protection Supervisory Authority of Latvia. So you are the one actually bearing the weight and the pride of this regulation. How do you think Foresight can help you supporting data protection?
Yeah, thank you very much. Good afternoon, everybody. Yeah, and I'm representing DPR, the bad guy or girl. I do not know, according to the previous sessions yesterday, but I think that what we, as well as DPA, can do for the future, for the privacy, is to start thinking about the privacy as a value and to start educating society that privacy is a value. It may be think that this is very forthcoming steps and we need to do something now, but if you want to talk about the future, if you want a better future, you have to create it now. And how to create it now, to educate and as well society, to making privacy and personal data protection rules is by default as a value, because it's not only data that is processed, it's our free choices, it's a part of our human rights, equality, liberty, right to vote. And in our lives, we have quite a lot of the things which we are doing, like when we are going out of our house, we close the door because we care of our security. But in the digital world, in our privacy, in many statements, we see I have nothing to hide, and privacy already lost, everything is out. But it's not like this. And we still can change it. We can change our behavior. We can start to understand this as a value. And then when everybody starts to understand it as a value, it will come also for the new technologies. Because when you are, like we are all driving cars and we have security belts, and it's like natural, you have them. And I don't think that any company which produces the cars, when they produce new car, they say, in the end, they say, oh yeah, that there is security belt, we didn't thought about it. Now it have to be working like this. No, we do not do it. So why we do it with the personal data protection and privacy in such a way? We first of all create the technology and they say, yeah, there's this obstacle data protection. So start to work with the values. Another thing that we can do as well as a data protection authorities is risk assessment. And GDPR has already good tool as impact assessment. And what we can do, we can assess risks for the human rights. If there's lower risk, then we can stand it. We can get out of this. But if it's higher risk, then we can have to think about this technology, about the service. Do we really need it in our society? If it's so high risk on our human rights, because our human rights is who we are, human beings, free choices. And another thing as well, like Foresight, it's prioritizing. And maybe it's going like against of the GDPR Article 77, but I think the DPA has to have this prioritizing on the high impact or on the risk assessment, based on the risk assessment. If some technology or some things have a big impact on the society, on the human rights, and is higher risks, then we do it. We look at this, we look maybe even preliminary before the service created. But if this technology, we see that this is very low risks, we do not go with this because, you know, in all strategies, one of the strategies is as well to say what you will not do. So I think that this education as a privacy as a value, risk assessment on the possible technology development and influence on the human rights, and the prioritizing would be this foresight things would help as well DPA to be more effective and more creative.
And what more can you do to get prepared to these challenges?
What more? I think that another one, this as DPA, I think that preparing this list of prioritized things. I think this as well, it's quite good what we have discussed these days as well, cooperation between the member states, between the DPAs. And for example, we have a lot of technologies that we use in each country. For example, like car sharing applications or taxi applications. They are different ones, they are working in different countries. So why we are not getting this and looking with a common operation and cooperation with other DPAs on this different application. So you just do it once. In like DPA, you check one application, but if each DPA would do it in one time, so we check all these applications through the Europe and we have united understanding what you need to do and how you need to process data for this one application. And if there will be new company, new controller who wants to do it, he already knows what to do, how to comply. And then as well, we as DPA, we have less work to do.
Right. Well, this is very much along the lines of what the supervisor said just before lunch. The fact that the measures arrive too late and then the impact is too little. So we need to be able to anticipate, and he was, quote, impressed by our thinking about the future. So thinking about the future, I'd like to introduce our second panelist today, David Barnard-Wills. He is the Research and Innovation Lead at Trilateral Research, an ethical AI company providing data protection compliance services as well. David's research has included international collaborations between supervisory authorities, SMEs' experiences with GDPR, privacy by design, and technology foresight experience. So, David, taking this from here, the role of foresight in this arena.
Yeah, I think I would echo the message that this is something that coordinates quite well. Right? Foresight activities can be shared quite well, and that would be something that would benefit data protection authorities across Europe by doing this stuff that you can, you do it once and you share it. You can do it in public. So you can kind of do foresight activities in public, and then you are coordinating amongst yourselves. You're also helping them to sort of shape the public perception of possible futures. We've had sort of 15 years of experience of working with data protection authorities, but also with organizations to try and help them identify data protection risks, anticipate data protection risks and respond to those. And a few years ago, we did a research project where we were looking at collaboration between EU DPAs, and we interviewed representatives from nearly every European DPA. And one of the things we asked them about was technology foresight practices. Do you do any, what is it? Have you published anything? And as you might expect, a very mixed picture. Some of the larger authorities had teams, and they produced reports and studies, and then many other authorities had nothing, or nothing systematic, only very ad hoc, kind of responsive, trying to find out about a new technology in the, during a case. But there was this interest in coordinating it and sharing it from learning from the activities of others, and I think that's something that's very worth doing. One of the benefits for that is, from our perspective on the outside, is it helps innovative companies. So if we want to do the right thing, having some input from regulators earlier on in the innovation process, it helps, right? Helps the people who want to do the right thing do the right thing. Building on the work we've done in Foresight, I think I can see sort of 5 levels where foresight and data protection come together. One is the classic kind of strategic foresight. So this is where you're trying to understand where your organization might be in 5, 10, 15 years' time. So you'd be doing scenarios or looking at key trends or kind of This might even involve trying to identify what strategic cases you might be looking for in the future. What would that case look like? So when it happens, you recognize it and you can respond quickly. Then there's technology horizon scanning, where you're just kind of looking at trends in kind of the research world and technology developments, trying to understand what new technologies are emerging and what some of their characteristics might be, like how close to the market are they, or things like that. Then there's technology deep dives, where you take a particular technology and you try and understand it as deeply as you can. And often that's about trying to cut through the hype around a particular technology that its developers are selling. And a variety of that are the kind of ethical, privacy, human rights impact assessments. So we do a lot of that, where we're trying to understand what are the potential issues that come out of a new technology. And that takes a kind of societal view as well, right? So you're looking at that from a kind of social science perspective. You're trying to understand how have similar technologies impacted the world in the past. And then finally, very, very granularly, within the data protection impact assessment, there's an element in there where you have to anticipate or assess the risks to the rights and freedoms of data subjects. And that's a small-scale, localized foresight activity, right? If you are just looking to easily comply, just go, no, I don't see any risks, But if you seriously think about it, if you put some structured approach to that, then you can actually develop scenarios, you kind of do little vignettes of how real people might be affected by these things. Then you can actually try and do like a deeper, richer DPIA. So you get these foresight models that work from the strategic to the very granular.
And this is a great cross-cutting description. How do you think could you describe and possibly overcome the challenges that foresight activities, DPAs, are possibly facing?
So there's a few. Some of the challenges come from the fact you're working with technology and complex technologies being used in a particular social context, right? So there's lots of different. So you need that cross-disciplinarity. You need technologists and lawyers and ethicists and sociologists and historians of the history of science and technology, to pull these different perspectives in. And you can't always look at a technology in isolation. You have to look at it with a set of other technologies as well. Some of the challenges are more about who else is doing this activity. So there's an information asymmetry between regulators and the organizations developing technology, who, by the nature of it, have a privileged perspective on what they're developing. Right? They will know more about it than regulators ever will. And the third one is a cultural issue within data protection authorities. Not all, but for some, this is just not on the radar, I think. And there are some internal barriers there to being anticipatory. Waiting for a piece of legislation to come along before feeling you have the competence to kind of do it. One of the advantages for foresight activities is you don't need any new powers or competencies to do these things. For some of them. But for like the strategic stuff, the kind of trying to anticipate the broad trends, horizon scanning, you can just you need budget, but you just do it in a sense.
So a couple of things I'm picking up from your remarks here, David. The fact that foresight is a systemic endeavor, and it has to be carried on at a deep enough level, because otherwise, something I really picked up from your remarks here, my risk register. Oh, I have no risks. Not really. Maybe if you think you have none, I think you should really rethink the way you're thinking about risks and thinking about risks in a foresight time horizon. And this is why I'm happy to have Stephen here. So Stephen is the Director of Technology and Innovation in ICO, which is the UK's independent body set up to uphold information rights. Stephen leads ICO's team responsible for anticipating, understanding, and shaping the impacts of emerging and disruptive technologies and innovation on people and society. Stephen and his team engineer information rights into the fabric of new ideas, products, and business models. Steve.
Thank you. Well, look, I want to use today to talk about three things. First, to say that prevention is better than cure. Second, to say that if we're going to achieve that, well, we're going to have to use some foresight. But third, to say that we're going to have to do that together. No individual authority can do that alone. So why is prevention better than cure? I've picked up quite a lot of noise around the conference around cookies, a technology that is several decades old. And yet we are still trying to work out actually how to make that online tracking environment more privacy preserving. For me, that's why at the ICO, actually, we are really leaning in and looking like, what are the next generation technologies in this space? That's why last autumn, to try and shape the market, we published an opinion setting out our expectations on the development of new proposals for methods of online advertising, and made quite clear the sorts of things that we want to see resolved in new technologies that emerge. And it's why with the Competition and Markets Authority in the UK, we have really leaned in to scrutinise the privacy impacts of the proposals from Google to phase out third-party cookies in its privacy sandbox. And why we're really pleased that working with the Competition and Markets Authority, they and Google concluded a set of legally binding commitments that would include privacy, include a role for the ICO in particular, actually, in terms of monitoring and evaluating the impact on privacy before the technology is introduced. And actually, that's a really radically different way of operating to the way that we're often thinking about right now. Now, foresight doesn't mean waiting for Google to tell us what the future is going to look like. As Director of Technology and Innovation, my job is to anticipate the data protection challenges arising from emerging technologies and to try and shape the response to those. And that's why, since I've joined the ICO, I've established a technology foresight division specifically to look at what is coming up in the next 2 to 5 years, whether that's the future of biometric technologies, whether that's neuroprivacy, whether that's immersive technologies like AR and VR, whether it's decentralized finance, because ultimately, prevention is better than cure. We are only going to try and really succeed in influencing change if we're clearer about our views as data protection authorities earlier on. That's not being in a rush to regulate. That's simply saying and identifying what we think some of the emerging challenges might be as we're starting to see it, rather than wait to enforcement. And it's why the Information Commissioner's Office offers a growing range of services for innovators to engage with us and to get clarity from us on how we think data protection law applies to a whole range of emerging technologies, whether that's light touch advice from our innovation hub or more detailed experimentation with us over a longer period through our regulatory sandbox. It's not just good for business, just to be clear. This is good for data protection. This is about making sure that data protection is designed in upfront, that we have early and candid conversations about the risks that might be emerging, and that we are active as a data protection regulator in terms of giving steers to the market. But we can't do this alone. Most data-driven technologies don't just have an impact on privacy. They have impacts on safety, on resilience, on security, on competition, and there are trade-offs to be made in this arena. And, we're seeing right now the DSA, the DMA sort of come into implementation in Europe. There are parallel developments in the UK, and we need to work with our counterparts here. If we're going to provide regulatory clarity on what we think about technological challenges as they emerge, we can't just do that as the Data Protection Authority. We have to work, just as in the case with Google, for example, with partners like our competition colleagues to set out actually what we think. And that's why in the UK, we're very pleased to have established a digital regulation cooperation forum to work across the online safety regulator that will be Ofcom in the UK, the Financial Conduct Authority, the Competition and Markets Authority, to make sure that actually we are trying to provide regulatory clarity and coherence here so that people know our views up front, because prevention is better than cure. And that's why I'm so pleased to be here today, because that, just in the same way that technology doesn't just cut across different subject domains, it cuts across borders. And actually, it's so important that we join up as regulatory authorities and talk about this and actually work out how are we going to connect, how are we going to join the dots between our different teams so that actually we're not putting out conflicting signals here, which is not going to result in change in the market, really. It's actually by taking concerted efforts and working together that we're going to achieve change.
I'd like to follow on 3 points I'm hearing from you. One, very clearly articulated, prevention is better than the cure. Absolutely. The second one is about regulatory clarity and coherence. And the third one is about how technologies are changing the values and the cultures of what we're trying to regulate. And here I'd like to just mention the second Dator's law on the future, which says that any useful idea about the future should seem to be ridiculous at first. So if we're not thinking ridiculous, probably we're not thinking future. So how can we integrate policy thinking, current technologies, imagined technologies, all together so to have the perfect mix?
Look, I mean, this is why we devote such a substantial chunk of our resources into our innovation activities within the ICO. And it's about really that spectrum from going from thinking about, well, actually, what could the future be like in 2 to 5 years' time, making sure that we are doing proper, rigorous, robust, ongoing horizon scanning to think, well, actually, how are we going to be picking up the sort of the channels and signals? But then it's also about making sure that you've got the ways of those signals being raised with you. So actually, what, as a data protection authority, are you doing to make it attractive for innovators to engage with you and tell you what they're doing? Because if you are deterring them from speaking to you, then actually you're not finding out what the future is looking like at all.
This is the perfect bridge, I think, to have William chime in this conversation. And let me reiterate how staggeringly high the level of this panel is, and I'm so proud of having you all here today. William Malcolm is the Senior Director of Google's International Privacy and Consumer Protection Function, managing a team across Europe and Asia. William has represented Google with global policymakers and has helped Google's product and compliance teams formulate internal policy plans on GDPR, right to be forgotten, AI and machine learning, cloud privacy, and international data transfers. William, hearing from all the speakers just before you, there's a piece on coherence, there's a piece on collaboration. We have seen how understanding inputs to the system is of primary relevance. And with this lens, the role of Foresight from your point of view, coming from this #1 corporation in the world.
I think the thing I want to say to start is that making strong investments in GDPR programs and GDPR foundations gave us all the tools and the machinery to invest in risk analysis and foresight activities. And I think the previous panels covered data protection impact assessments, all of the compliance apparatus that companies now have embedded that enables them to make that investment. But for me, I think foresight shows up in 3 ways. Really, it's about helping us see across issues. It's also about helping us invest in standards for the long term. And it's also about helping us see how technology, as well as policy and law, can be part of the long-term solution to balancing some of the debates that we're seeing today. Maybe if I could just take a minute or so on each of those. So seeing across issues, I've heard a lot at the conference about the complexity that's coming with DSA, with DMA, with the Data Act, with the Data Governance Act, with the AI Act, with the need to look across various issues from competition to content, to access to information, to privacy. And I think really to deliver on the promise of all of these legislative instruments, we are all going to have to work together, and we're going to have to invest in seeing ahead and seeing what the challenges are in each area. I would also highlight the work that Google has done with the UK Information Commissioner's Office and the UK Competition and Markets Authority is a good example of that activity. And at its core, it's about investing in new technologies. It's about Google using technology to say, how can we recognize that there are legitimate concerns about cross-site tracking and about the use of third-party cookies? How can we move beyond that to a more privacy-safe world whilst balancing that with legitimate competition concerns? And I think having a shared dialogue, a shared conversation, having technologists in the room from Google with both regulators really helps us get there and really helps us build solutions for the long term. The second issue I would go to is around standards. Enforcement is always going to be and always should be an important part of the regulatory toolkit, and I wouldn't minimize its role. But there are lots of other articles in GDPR dedicated to seals, codes, certifications, how we can work together. And to respond to the new challenges that I've just outlined, which aren't just about 100 privacy laws that are emerging all over the world, but 100 content and competition analogous instruments, we're going to have to invest in standards and find ways to scale compliance in ways that delivers on the promise of this legislation for Google's users and for society more generally. And the last point I would come to is technology can be part of that solution, and Foresight helps us see that. If you take examples from the pandemic of Apple and Google coming together to work on contact tracing technology, or if you take examples that I've just outlined about investing in new forms of APIs in the privacy sandbox, technology can be part of the solution. I'm constantly astonished and amazed what our engineers can do with technology to balance and solve some of these problems. A really simple example would be, our investments in federated learning, which have allowed us to learn new words from what you type without data ever leaving your device. So technology can be part of the solution. Collaboration across regulators and across issues must be part of the solution. And investment in standards and investment in a long-term approach. Those are the things that Foresight can deliver. And that's the direction of travel that I think for Google we want to embrace, because we think that will help us get to a better future for our users and deliver on the promise of all of the legislation which we recognize is vitally important in this moment.
It's fantastic how you frame, and I think it's a message that came across loud and clear how technology, and I really want to reiterate this, technology can and has to be part of the solution, because too many times what I'm hearing in many forums, the fact that there's this worn out narrative of human versus machines, and how robots will take our jobs and all that. This is simply worn out. It's simply old. Human and machines, human and technologies are able to deliver more than just humans and just technologies. But as you've been so forward-leaning in your opening remarks, William, I'd like you to ask kind of a question turned upside down. Meaning, instead of asking you what we can build, I want to ask you, what are the limits to integrating Foresight into the legal and regulatory practice?
Yeah, look, we all try to predict the future. We all try to build technology that meets the needs of society. But it's absolutely important that users come first. technology should have users at the center. And so it's a constant need to evaluate, a constant need to test with users to get that feedback, to understand what's working and what's not working, and to understand that across different cultural contexts. So that would be one point I would flag in response to your question. The second would be that the unpredictable happens. Like, again, we saw with the pandemic that we've lived through the need for technology companies, for public health authorities, for regulators to come together in new and innovative ways to new forms of regulatory dialogue, new processes to review technologies and ensure that they're delivering on privacy protections and benefits. So I think the answer to your question is probably, life can be unpredictable and we have to respond to that, and we have to constantly evaluate what we're hearing from our users and how we put them first in the technology we build.
Wonderful. What I'm hearing here is once again stressing how important it is to render Foresight a systemic and organizationalized capacity within organizations, and the whole of business, whole of government, whole of nation, because it's kind of this red thread which enables us to deliver more, understand more, how can we make better decisions overall. To this point, I'd like to introduce you Chris Nagomez. Chris is a human rights lawyer and a futurist whose mission is to radically democratize foresight. She works with many security actors around the world, and so that they can engineer change, not just adapt to it, and experiment in a simple, fast, and frugal way with experts in tech, neuroscience, marketing, and communication. Chris, speaking of democratizing foresight, your take in foresight in data protection, also in the wake of what we just heard from our speakers today.
Well, I guess it's a take on the marriage of foresight and law, or law enforcement. So I'm a lawyer, and I'm a human rights lawyer who works with activists. I don't know how many of you know them, live with them, are married to them, or have once been an activist, but we're a very particular breed. We're very good at reacting. We take pride in our contingency measures and being able to respond to emergencies. What bothered me about that way of thinking and working, and which I see in every realm that involves law and law enforcement, is that we feel that we have to wait for the fact, we have to wait for the violation, and then we respond by enforcing the law. But that's particularly tricky in a field that deals with a realm that evolves at breakneck speed, and that is technology. So, Jekaterina talked about educating society, and Stephen talked about engaging everyone, not just the data protection agencies. Absolutely. To me, foresight is absolutely different techniques and activities, but ultimately it's a muscle. It's like a sleeping muscle in our bodies that we have to wake and we have to train in very small ways. And there's a whole neuroscience to it. It turns out that we're not naturally wired to think like futurists. We are more concerned about today. There are MRI scans out there done, scanning the brain for activity when you think about your future self. And apparently, we treat our future selves like strangers. We don't have as much empathy for it. Can you imagine treating data protection enforcement of the future? But the problem with not doing that is, Stephen, I love your example of cookies. That's what's been bugging me throughout this whole thing. Cookies, we're moving into a cookie-less world in a few years, at least third-party cookie-less world in a few years. And we know that 5G will radically amp up the amount of data that is generated, stored, and collected by exponential terms, not in 20, 30 years, but in a few years. How do you then make sure that you don't just focus on enforcement based on reality today, but instead there's this term called future benchmarking, where you try to already integrate and adapt to the best practice of the field, not today, because by the time you do that, it would have been 5 years to adapt to it, then it's already moot, academic, and passé. But try to imagine what would be the realities 10, 20, 30 years down the road. Regardless of what prediction happens, prediction doesn't matter actually. Come up with a few different scenarios, deduce the strategic questions and capabilities that are required by them, demanded by them, and work backwards from there to then design your enforcement mechanism today. By doing so, you actually solve for tomorrow, but also today. And you don't do that by hiring a consultant like me to tell me the future of data enforcement. No, the best way to do that is to build and train that muscle in every single person in your organization and community. And it's doable in simple ways. So next week, I'm gonna run a Futures Club with my friends in the community. It's like your book club, but we're not gonna read a book, we're going to simulate a scenario. And I know that here in this hall yesterday, Alessandro and Stefano ran a simulation of 3 crazy scenarios with 15 people. And the amount of collective intelligence that you can draw from that is immense. And I was, okay, I'm putting you on the spot now. I was telling them, can you imagine running that simulation at the level of thousands or millions of people across Europe? And that's being done in the tens of thousands now. You can check out the Foresight engine of the Institute for the Future. They're doing that where they run simulations of the future over 24 hours online, and they get thousands of ideas, reactions, and they even managed to simulate the pandemic 10 years before it happened. Now, again, this isn't about prediction. It's the fact that those people who simulated it had developed neural pathways that when the pandemic happened, they weren't shocked. They knew exactly what to do. They weren't paralyzed. They knew exactly how to respond and how to help others. Now, from the point of view of enforcement authorities and those who work with them, can we dedicate equal amount of time to solving for today's regulatory and enforcement gaps and imagining a future where 5G is a fact of life, where sensory devices are a fact of life, where human data generation doubles every 6 months, and then make the design of enforcement today? It's fun. It's scary, but like what you said, Gabriele, if it isn't ridiculous sounding to you, if it doesn't make you uncomfortable, then Foresight isn't doing its job. You have to shift a bit in your butt and your seat to know that, okay, I'm getting out of my comfort zone, and that's the best space for creativity.
Absolutely. I mean, I'm just follow on this, on what you just said. The Foresight is a muscle which we have to train not tomorrow, but today. And because everyone, we don't know the future better than you do. The whole point is being able not to just think about the future, but to do futures thinking. So we don't just train our, we don't just use our anticipation capacity, which is just everything every one of us has, the ability to imagine ourselves in the future and drawing decisions about what we decide, or what we imagine. But actually training this imagination in ways we're not used to, which is what we call futures literacy. And this is exactly what we need to do. So I'll then now exert the executive privilege of being the facilitator and moderator here to ask the first question to this very distinguished panel, to open the floor for then questions from either here in live or online. And so here's my first question to the whole panel. We can see the presence of Foresight in data protection as the premier existence of anticipatory compliance. Similar to what we had with cybersecurity, so the existence of a European cybersecurity label, I'm wondering, what do you think of a Foresight label for these activities?
A Foresight label for
data protection, for the organizations, for businesses working on this.
Like a certification, but you're
Exactly.
Foresight certified.
Exactly. You have a standing Foresight practice.
So we did some work a few years ago on the feasibility of a European privacy seal scheme in the basis of the GDPR. So I have a bit of form on data protection seals and certification, and what wouldn't work in that field is a broad, certified privacy seal. But what might work are like subsections of that market, right? So you certify a particular set of things. So I don't know, there's perhaps a gap in there for this technology has been designed with some foresight practices involved. I don't know how standardized foresight practices are and whether they have any kind of quality assurance that would make that.
I don't know about the certification thing, because I think the moment you put a label on it, or the moment there's aspiration towards a label or a certification, it gives incentives to organizations because they have to comply. It's for legitimacy and reputation, but it doesn't trickle down to the human beings in the organization. And I'm obsessed with neuroscience, and we found that any major change you want to introduce, you have to introduce it through fun. And if it's not fun enough, come on, I work with activists who deal with life and death situations. But what works with them, with us, is if it's fun enough and they see that it's relevant in their day-to-day life, you wouldn't have to dangle a certification before them, they will do it. That's why I'm very excited with the idea of gaming and simulation. Talk to a gamer, and you will know how powerful gaming is in rewiring the way they think. In even convincing them that they can solve world problems, because that's what a lot of video games, the most popular ones, are. They're fixing world problems. So I would move away from labeling, but really making it so attractive that every individual would be excited to practice foresight. If you want to get started with this, there's a super exciting book that has gotten me super excited recently. It's called Imaginable by Jane McGonigal. It makes foresight so accessible, so fun, and so compelling that I even used the imagination exercises there with my husband. One time we were on the beach and I asked him to close his eyes. And after that, we had really good conversation about future. So I think making it fun, and I think EU and fun can go along together.
Maybe just going further for the foresight futurist and future thing, I think that in the data protection, in many cases, what we use as well is DPA when we have something new. And in many cases, as DPA, you have a lot of the new cases where there's no rules of the law and a lot of things of maneuver where you have to decide. And it could be as well part of the foresight, but we always think that, is it this future where I want to live? Where is it the future where I want to belong? And that how you use and that how you resolve as well some questions in the data protection in our point of view. If you are content with what you see, what you want to be, then it's okay. If you are feeling not so good and not so human afterwards, then maybe it's not the best way and not the best technology.
So I'd say, I don't think it's about certification. I think it's about values. I think it's about wanting to be a intellectually curious organization that is really trying to strive towards the future. And that doesn't matter whether you're the regulator or the regulated. And so, actually one of the things that I find is that actually working in this sort of space is a huge draw card. There are lots of people who would really love to be able to spend their time trying to work out what the future looks like, what the scenarios might be, how might data protection law, which is so gloriously principles-based, but then means that you constantly have to make interpretation and judgment, how does that play out in these different scenarios, and how are we going to respond? I think it's the incentives to do it should all be there themselves. The reason sometimes the incentives don't work is because foresight will never be 100% perfect. And so you will always be in this sort of world where people will go, well, actually, did we do this really due to foresight activity? Really because we were kind of ahead of the curve, or did we kind of catch it kind of late, et cetera? And so actually, maybe this foresight activity looks a little bit too fun. Is it really work? Is it, but it is work. It really is work. And I just wanted to come back, so just to flip the point around certifications, because actually I was really interested in what William was saying around sort of the role of certification, more generally the role of industry-led governance here. I was kind of kicking myself in a way that you do when you're sat with somebody who's made a very good point that you'd wish you'd made yourself. Because actually there is a huge role here for industry-led governance itself to have foresight built in. So whereas the foresight around the development of industry standards, for example, how are we making sure that those governance mechanisms that really support regulation are not anchored in the past, but actually they are moving towards a better and hopefully, from my perspective, a privacy-enhancing future. So foresight's not just for regulators, not just for the regulated, but it's also for the other actors in the space too.
Have we got any questions from the online audience? Oh, we have a question from in life. Please, do we have a mic for this gentleman? No, we haven't got one.
I'm Stuart Dresner from Privacy Laws and Business. And my question is, I'm interested in the interaction between the ICO and Google, in the fact that you worked with them on a particular project, which was to do cookies that had the term sandbox, which is a bit confusing because the ICO has its own sandbox program. So obviously that's a little bit confusing. But the main point is, how does the interaction with Google differ from the companies which are in and have been in the ICO sandbox, which is an innovation center to enable companies to talk with the ICO before they launch a program to make sure avoid problems in the future. So that's a very praiseworthy and wonderful thing. And for example, OnFido has done that. That is a facial recognition company which, by talking to the ICO in advance, managed to avoid all the problems which Clearview had. So that's good for the ICO and good for Clearview and good for citizens. So my question is, how does the interaction with, by the way, we've written an article on that in Privacy Laws and Business, happy to send to anyone who gives me their personal data, their email address. But anyway, I want to know, how does your interaction with Google on their particular issue differ from the companies in the ICO sandbox?
First up, thank you very much for clarifying for everybody, because sandbox, what a lovely contested term. A regulatory sandbox is a very different thing to a sandbox in a technology firm. And so, ours, it definitely has the principle of it being, a kind of a safe place to play, but it's a safe place to play with the regulator, with us looking at and scrutinizing things as they develop. The short answer is actually the nature of the cooperation here, not massively different here. This is us working together ex-ante, before the changes are made, and looking at how the technology develops and providing regulatory steers into that process. And it is one where there are certainly kind of a number of evolutions that have, you can see if you dial into the sort of the developer space, that have evolved as time has gone on, as more regulators have provided their steers into the development of Google's own privacy sandbox, where it's phasing out third-party cookies. So I'd say not wildly different. I'd say also, though, please don't be under sort of an illusion. I described a sandbox as this nice place to play. It's probably nice up to a point, right? We're still regulators. We still have very clear privacy expectations, and we're very clear that we'll go up to a point, but we have a slightly grumpier side too, that we're not hesitant to reveal should we not quite get to the right result. But
I'd just quickly add to that answer by saying that with the CMA, of course, we were in a formal regulatory process. I think but that aside, I agree that the nature of the dialogue, the open exchange of views, particularly on the technology, the future of the industry, the future of standard setting in that area, bore many similarities to a regulatory sandbox, perhaps with one twist, which we had two regulators together, right, working across a tension between our desire to have privacy-safe advertising that supports an open ecosystem, and the legitimate and fair regulatory expectation that we address some of the harms that have been labelled at third-party cookies and cross-site tracking. So you have that two regulators in the box, if I can put it that way, which I think is new and different, and perhaps one of the first examples in the world of that type of activity. So yeah, those are the supplementary points I would make.
Thank you. Was it a formal three-way dialogue or trial between ICO, Google, and Competition Markets Authority?
Just a yes or no answer.
Yes.
Anyone from the room, or do we have? Oh yeah, yes, we do.
Hi, Sam Clark from MLEX. The UK government released its data reform details this morning, and that says that the ICO will have to have greater emphasis on taking into account growth, innovation, and competition. Will you do more of this Foresight stuff following the data reform?
So the short answer is yes. But this is an ongoing direction of travel for us here, and it's not just about driving economic growth. It's also about delivering for privacy. We are going to deliver better results and be a more effective regulator by being a regulator that is focused on what is coming down the track and making sure that we are providing steers, we're providing clarity, and we're supporting people to comply. And that's great. It's good for business, it's good for privacy, it gets us the best outcome.
Anyone from the room? Or I can have a question from online. I do have a question then, which is about sourcing Foresight. Because we have discussed a lot of what Foresight can do in this environment. How do we source it? Where do we source it from? How do we integrate with the organization? I'd like a short roll call through the whole panel, and then we'll wrap it up. Who wants to go first?
I can go first.
All right.
My favorite source, it's like the creative raw material for foresight or futures thinking. It's called Signals of Change. You know how when we read our newspapers or news app, we focus or we tend to read the front page articles, like the headline. Those represent like your trends, things that everyone already knows. But imagine reading the article in the bottom right corner of page 14 of the newspaper that no one else is reading and you would often overlook. It's about an innovation so localized, so small, but if it becomes mainstream, it will alter reality forever. So those are signals of change. They're the peripheries, they're the fringes. It could be a new research, a new product, an anecdote you heard over dinner, and then mix different signals of change across different domains, not just the domain of technology or politics, but society, fashion, pop culture, because reality is integrated. Then use the signals of change, mash them up, and come up with what possible futures could we be looking at and anticipating and building capacities for.
William Gibson, the prolific sci-fi writer and the creator of the word cyberspace, used to say that the future is already here, it's just not evenly distributed.
Yeah.
Anyone else from a panel?
I think the strongest signal still remains what we hear from users through feedback, through what we see online, through the comprehensive testing of products we do, through the listening initiatives that we take. And I think, we can anticipate, our technologists, our engineers can anticipate a lot of the issues and challenges in deployment of technology. But that feedback loop of listening to users, hearing their concerns, and hearing how issues are showing up for them, I think remains the best and most accurate signal of what's coming next.
So you can certainly find existing trend research from various different sources, and that's useful up to a point. But for the most valuable foresight activities, I think, particularly for this environment, it's doing it yourselves is going to be quite good, right? It's going to be quite a useful thing to get different regulators together or within a regulator to try and imagine that potential future, because it's their potential future that they'd like to create on behalf of citizens. So you can get an external consultant in to kind of come and run it for you, but there's a real value, I think, in doing that sort of activity like organically. If you are getting somebody else in to support you with it, you will still need to be involved. You still need to be kind of active participants in that process. It shouldn't just be like, oh, here's my Foresight report, I'll read it and understand the future. It's good to have an internal plan about what you want from it, and then you can get the help to help you do it.
It's okay? Oh, thanks. So maybe from one procedural perspective, as DPA, as a governmental institution, I would say for me, the Foresight sources, first of all, is some proposals of the legislation, because in many cases, the legislation proposals comes, or you know that it will come, and it will be like 5-6 years of the discussion, then it come to enforce. And in many cases, what I see as well in the governmental sector, where I'm working quite a long time, when it comes to enforce, we will think about it, but you cannot do it. If you start hearing of this possible legislation, you have to think how I will act after the 6-7 years, or how can I change now this legislation in order to be more compliant and in order to better enforce it. And it's like one more of lore thing. And another source of Foresight, what I can fully agree, is some researchers, because in many cases when I attend some conferences on private sector or startups, and you see these ideas and it's professional, you start to understand, okay, they want to do this, but what they will do with the purpose, what will they do with the data minimization, and then how you start this sourcing, because now you know, okay, this technology comes, maybe not today, but after some years. So let's think about it, what we will do when it comes. And maybe we can already now say that this is the red lines. Because what I think in data protection is quite important as well, to set these red lines, where the border you cannot cross. Before this is this negotiation process that you can go with the safeguards, with all other things, but then this red lines, it's quite necessary, I think.
Anticipation and foresight are all about making better decisions, future informed. So Jekaterina, David, Stephen, Chris, William, thank you so much for being part of this panel. And Last question? 1 minute.
It was so interesting that I forgot to ask the question.
Wonderful.
So thank you, first of all, for the session. It was the best one I followed so far. So I wanted to come back to what Mr. Barnard-Wills said before, to the identification of the risk. So when you're saying all the steps to follow from the let's say DPA, from the strategical point of view until the DPA, and before the technology is introduced into the market. Do you see an additional risk, that is the risk that the technology goes into the hands of the users? So if I think about, for example, Google Glasses, that they have a lot of future, they can record, they can take pictures. You can make the best DPA that you can foresee the perfect retention, you can make sure that the data are stored in Ireland, but how do you mitigate the risk that users are misusing this technology? Yeah. And how do you prevent this risk? Do you think it's possible to do something? Because then the tool goes into the hands of the users, which are those who purchase this tool, and they want to make the maximum use of those technology. So if you step in and say, no, you cannot use these glasses for this purpose and this purpose, you are basically limiting the value of the goods that the person has purchased. So is there a way to mitigate this risk? Or first of all, if you see this risk as well,
a succinct answer, David,
yeah,
please.
so yes, we look at, when we do a privacy impact assessment, or in a research project where we're looking at potential impacts from a new technology, we try and take a broad approach as possible. So not just what are the data processing risks, but broader social, ethical risks like those posed when it hits the world. So we try and include that in our thinking. Interdisciplinary research. So sociologists and cultural studies people and anthropologists and
Can I add something? But here comes values. If we are talking about the user, this is values. And if you educate user with the values, and value is a privacy as well for user, then they will not abuse technology. And that's why I'm thinking that part of the prevention work as well, maybe for the DPA, it's educating the society. So if this is value, you treat it as a value, and you do not do it. Thank you.
This is, by the way, why any useful idea about the future should seem to be ridiculous at first, because when we see this from a present-oriented perspective, we don't usually get grasp of the changes in values and culture that are being brought about by technology. All right, so let me please join me in a very big and warm round of applause for our speakers here. Thank you very much to you all here in live and those following us online. Enjoy the rest of your conference.